Ready? 3, 2, 1, start. There is no provision of law which provides for initial probation and extension thereof. Stop. A maximum period for such extension is provided beyond which it is not permissible to extend the probation, and inference in such cases is that the officer concerned is deemed to have been confirmed upon the expiry of maximum period of probation if the order of termination has not been passed before its expiry. It is submitted that the appointment letter stipulated that upon completion of 2 years probation, the services of the respondent number 2 shall be confirmed, and therefore, after successfully completing the maximum period of the probation of 2 years, the services of respondent number 2 stood confirmed. Stop. Therefore, the order of the termination of services was misconceived totally, and it was without jurisdiction because that order treated him as a probationer. Stop. The question of deemed confirmation in service is dependent upon the language of the relevant service rules of the concerned department, and it has been the subject matter of the consideration before this court. Stop. There are 3 lines of cases on this point. Stop. One line of the cases is where in the service rules or in the letter of appointment of the candidate, a period of probation is specified and power to extend the same is also conferred upon the concerned authority without prescribing any maximum period of the probation, and if the employee is continued beyond the prescribed or extended period, he cannot be deemed to be confirmed. Stop. In such cases, there is no bar against the termination after expiry or the expiry of the period of probation. Stop. The other line of cases is that where there is a provision for initial probation and extension thereof, then a maximum period for such extension is also provided beyond the term which is not permissible to extend the said probation. Stop. The last line of cases is where the maximum period of the probation is prescribed, but the same requires a specific act on the part of the employer by issuing such an order of confirmation and of passing a test for the purposes of confirmation in that department. Stop. In such cases, even if the maximum period of the probation has expired and neither any order of confirmation has been passed, nor has the person concerned passed the requisite test in that department, he cannot be deemed to have been confirmed merely because the said period has expired. Stop. The termination during the probation could be viewed as a punitive action in some of the cases, but it has to be seen as simpliciter during the said period of probation. Stop. The court expressed the view that no abstract proposition can be laid down that where the services of a probationer are terminated without saying anything more in the order of the termination, and it can never amount to punishment. Stop. In the facts and circumstances of the case, if the probationer is discharged on the ground of insufficiency or for familiar or for similar reasons, and without his getting a reasonable opportunity to show cause against his discharge from service, it may amount to removal from service within Article 311 of the Constitution of India. Stop. While dealing with this principal question, the bench even discussed that a probationer can automatically be confirmed in the service on the expiry of period of probation. Stop. Probation period may be extended from time to time, and it can be done expressly or impliedly so that the total period of the probation does not exceed the time period. Stop. Termination of service could be done by serving 1 month's notice or paying the salary in lieu thereof, but there is no such provision in the appointment order. Stop. Appellant had filed a writ petition before the Delhi High Court, taking the stand that he was being tried in several cases contrary to the extradition decree. Stop. Appellant came to India by way of extradition from Singapore. Stop. Presently, the appellant was facing trial in 8 cases, which is in complete violation of the provisions of Section 21 of the Extradition Act 1962. Stop. He had also pleaded that he was being kept in solitary confinement without proper medical aid in the state of UP. Stop. It is to be noted that the appellant had filed the writ petition before this court, which was withdrawn by him in order to enable him to move appropriate High Court for redressal of his grievances, if any. Stop. Learned counsel for the appellant submitted that the choice of the High Court is entirely that of the writ petitioner. Stop. It is not in dispute that, in terms of Article 226 of the Constitution of India 1950, the appellant could file the writ petition in Delhi High Court. Stop. Merely because he had a choice of going before the Allahabad High Court, the Delhi High Court should not have refused to consider the writ petition, stating that the Allahabad High Court can deal with conditions of prisoners in the state of Uttar Pradesh more effectively. Stop. It is submitted that the basic grievance of the appellant related to alleged violation of the terms of Extradition Act as provided in Section 21 thereof. Stop. Learned counsel for the Union of India submitted that there is no violation of any term and no part of the cause of action had arisen in Delhi, and the Delhi High Court has rightly observed that the appellant can pursue his remedy, if any, before the Allahabad High Court. Stop. In the present appeal, we are not concerned with the question whether there is any violation of the terms of Extradition Act. Stop. The only question that needs consideration is whether the Delhi High Court had jurisdiction to deal with the matter. Stop. Delhi High Court accepted that it may have jurisdiction, but it was of the view that the grievance can be more effectively dealt with by the Allahabad High Court. Stop. It is not certainly a correct way to deal with the writ petition. Stop. Accordingly, we set aside the impugned order of the High Court and remit the matter to it for fresh hearing on merits. Stop. A prayer has been made for release of the appellant on parole for the reasons indicated in the application. Stop. We are not inclined to pass any order on the said application. Stop. Cause of action has been defined as meaning simply a factual situation and the existence of which entitles one person to obtain from the court a remedy against another person. Stop. The phrase has been held from earliest time to include every fact which is material to be proved to entitle the plaintiff to succeed, and every fact which a defendant would have a right to traverse. Stop. Cause of action has also been taken to mean that particular act on the part of the defendant gives the plaintiff his cause of complaint or the subject matter of grievance, which is not merely the technical cause of action. Stop. The cause of action means every fact which will be necessary for the plaintiff to prove it in order to support his right to the judgment. Stop. It has no relation whether to the defense that may be acted up by the defendant, nor does it depend upon the character of the relief prayed. Stop. It is the restricted idea of facts or circumstances. Stop. In a wider and more comprehensive sense, it has been used to denote the whole bundle of material facts. Stop. ये हमने 1225 शब्द लिखे हैं.